A proposed change to the Clean Water Act could significantly expand federal authority over private property.
Legislation has been introduced in the U.S. Senate that would remove the term navigable from the Clean Water Act when referring to waters under federal jurisdiction. The Clean Water Restoration Act, S. 787, is awaiting markup in the Senate Environment and Public Works Committee and is supported by conservation groups. But some farmers and ranchers are worried about what it would mean to their everyday operations.
This is something that if they take away this one little word, navigable, will open up like I say, open up a can of worms and could tie us up with litigation, tie us up in the courts. Anything that we do in our livelihood, it could limit that. And it would cost us more in permits, more in government regulation.
If adopted, the legislation would change existing law and grant the Environmental Protection Agency and Corps of Engineers regulatory authority over all intrastate waters. This would include ponds, ditches, or streams on private property, even those that only hold water for short periods following precipitation events. It would effectively overturn two Supreme Court decisions that upheld the original intent of the 1972 law and create a regulatory nightmare for farmers, ranchers, and other property owners.
And we feel like that is overburdensome, increased regulations, you have to have additional permits, and we quite frankly feel like that we're in a lot better shape when we have state and local governments have the regulatory authority over these waters.
Arkansas Farm Bureau has written letters of concern to the state's congressional delegation and asked other State Farm Bureau presidents to do the same. Farmers, ranchers, and agricultural interests are urged to contact Senators Blanche Lincoln and Mark Pryor and voice their opposition to S. 787, the Clean Water Restoration Act.